So let's get into some of more of the discussion of why we're seeing this sea change in the lower courts, and basically the Bruen standard itself is producing this. I want to get your take on I think you're fairly critical of that, and you're fairly critical of what we're seeing and the results of it.
And so, I'll say you mentioned that there are not every gun rights proponent is in favor of a text, history, and tradition test. And I often point to Professor Nelson Lund, who is a George Mason law professor and is strongly in favor of Second Amendment rights, held the previous Patrick Henry chair in Second Amendment law at George Mason. I think some of his critiques, even before Bruen, about the kind of test are what we're seeing come true, which is that the history is really hard to do, and it's hard to come to a determinate answer. That history does necessarily supply an analog for X or doesn't supply an analog for X. And his concern that he raised a few years ago was that what it's going to end up doing is drive the actual values decision-making below the surface. So whatever you think about intermediate scrutiny or strict scrutiny, at least the court there is putting on the table, here's the government's interest, and here's the evidence to support the government's interest. And do they match up or not? Is there enough evidence to support that this law is serving that interest? Whereas with historical inquiry, it's kind of hard. It's kind of opaque sometimes what rationales the courts are using to justify finding tradition sufficient or not. So in the Antoniuk case that you mentioned, the court at one point said, there's a historical tradition of banning guns in schools, but I don't think that applies to summer camps. Right? And it's not really clear what's doing the work in that analogy, right? What is the court seeing that's analogous or not between schools and summer camps? If you have a tradition that the court recognizes about firearm prohibitions in schools, is it what's different about summer camps? Is it that they're not required? You're not required to be in them. Is it that they're not always children? Is it that they're in special places? The court really doesn't say, and Bruen doesn't give a lot of guidance on how to actually draw the analogies. But I'll say in general about the test, I kind of have two concerns about it. One is at the conceptual level about what it requires courts to do. And then one is at the practical level about how much guidance Bruen gave lower courts. So at the conceptual level, one of the things Bruen says is that you've got to find a historical tradition of regulating in a similar way in the past in order to sustain a modern gun law. And to me, that's just inconsistent with the concept of original public meaning originalism, which the justices and the majority in Bruen purport to believe, which is that the understanding at the time of the Second Amendment's ratification is what should guide interpretation in the present. And it's just not the case. I think we can all agree that all of the laws that the founding generation thought they could have enacted, did they necessarily enact? So it's entirely, not just plausible, but I think undeniable that there are laws that the founding generation thought they could have done and didn't do because there wasn't a need to do them. So it doesn't have to be related to guns at all, right? There are other things that they didn't do that they had authority to do. But Bruen essentially erases that category of laws that could have been enacted but that weren't enacted, because it says that you have to find an enacted law in the past that's similar enough to a modern one. And to me, that just it provides an inaccurate understanding of the scope of authority at the founding generation. So instead of looking to, did the founding generation think about X conduct as a right that was immune from government regulation? Bruen says, instead, look at the other side. Look at, did the founding generation actually legislate with respect to X? So that's kind of my conceptual problem with the Bruen test. And that's why I talk about it's giving this oversized importance to the role of historical silence, which is if government didn't do something, then they couldn't do something. At the level of pragmatics, I think there are just a lot of questions that Bruen didn't answer. So even if you reject my conceptual concerns or say that there's other answers for those, I think if you're a district court trying to apply Bruen faithfully, there are a lot of concerns that lower courts are voicing about the ability to do that task, because Bruen doesn't even say how many laws you need. Is it a set number of laws? The Antoniuk court at one point said 3 laws. That constitutes a tradition. Other courts have said 7 laws. Some other courts have even said, roughly half the nation having this law does not make it a tradition. So that kind of what a tradition consists of, and then kind of related questions of, how many states had to have adopted them? How long do they have to last for? Does it matter what the population density of the given states, what these particular laws were? A lot of questions about how to apply the test in practice. Bruen left open, and we're seeing the lower courts that are reaching different results. So whether, it's constitutional to bar somebody with a felony indictment from acquiring a new gun, some courts say yes, some courts say no. That's not surprising, right? That's going to happen after any big ruling. But what is surprising, and I think more concerning, is that they're disagreeing about how to actually do the test. So some of them say it's a step 1 issue. Some say it's a step 2 tradition issue versus a plain text issue. Some say, we're applying a test that looks for a distinctly similar analog because this is a type of problem that has persisted from the founding. Some say we apply a different test when it's dramatic technological change or a social problem that hasn't existed. And then we're looking for a relevantly similar analog, which is not the same as a distinctly similar analog. So I think the problem on the practical level is that it's not that courts are reaching different results. It's that courts are applying different tests and are voicing their own confusion about what the test should look like.